This case is Hutchinson versus Toews. This was seen in the Courts of Appeals of Oregon in 1970. The plaintiff is named Fred Hutchinson, and the plaintiff was put in through his guardian Hill Hutchinson against the chemistry teacher Nathan Toews. So plaintiff and his friend Philip Brown, both 15 years old, attempted to shoot a homemade pipe cannon which exploded, and during the plaintiff's hands, they made the explosive charge by mixing potassium chloride and powdered sugar. Brown testified that he and the plaintiff had badgered defendant Toews, the chemistry teacher at Phoenix High School, for potassium chloride to use in fireworks experimentation. He said that they asked about a dozen times. Finally, Mr. Toews had given them some powdered potassium chloride, which they put in a baby food jar. A day or two later, when Mr. Toews left a separate chemical storage room unattended while he stepped back into his chemistry classroom, Brown took, without Mr. Toews' knowledge or permission, some crystalline potassium chloride also stored there. Brown positively identified this crystalline potassium chloride as the substance used in explosion, as he was the one who mixed the ingredients. The plaintiff first indicated that he didn't know the substance that was used, but then he said it looked like crystal. Brown waited approximately 2 years after the accident before he revealed to anyone that he had taken the crystalline substance and that it had caused the explosion. The plaintiff did not reveal that he knew the crystalline substance had been taken until after Brown's disclosure of the true facts. The injury occurred in November of 1965, and the plaintiff commenced this action for damages against defendant Toews only in June 1966. And then he filed an amendment complaint in August of 1967. In these complaints, the plaintiff alleged that defendant Toews supplied the potassium chloride to him. The issue at stake is a teacher liable for the behavior and or negligence of his students? The holding was that the injured student with knowledge of the risk involved is contributorily negligent. The legal rationale was based on the evidence provided. The court determined that the plaintiff knew the risks involved and that he was contributorily negligent as a matter of law. In page 673, at the top it says, Prosser says, the kind of contributory negligence which consists of voluntarily exposure to a known danger and so amounts to assumption of risk is ordinarily a defense. So they decided that he knew the risks, so that Mr. Toews was not liable for their decisions.